5 seconds to go. Start. It is further case of the petitioner that the state government by the notification dated 6 February 1991 deputed police personnel of various ranks to Karnataka Lokayukta, and in addition to that the notification was also issued under the provisions of section 17 of the PC Act, empowering the rank of police inspector and above to investigate offences under the PC Act. By such notification, the police personnel on deputation to Karnataka Lokayukta were placed under the administrative and supervisory control of Lokayukta and Up-Lokayukta as the case may be. The very object of the notification referred above was to remove the bureaucratic control and political interference in the matter relating to corruption, irrespective of the rank and position of the accused, either in the bureaucratic or political circles. At this stage, it has to be stated that a person to be appointed as the Lokayukta shall be a person who has held the office of a judge of the Supreme Court or that of the Chief Justice of a High Court, or a person who has held the office of a judge of a High Court for not less than 10 years, and a person to be appointed as a Up-Lokayukta shall be a person who has held the office of a judge of a High Court for not less than 5 years. Thus, the police personnel who were deputed to Karnataka Lokayukta were placed under the direct control and supervision of a retired judge of the Supreme Court or the Chief Justice Judge of the High Court, with an intention to command highest respect and fearless, impartial and fair investigation to be conducted, even though Lokayukta and Up-Lokayukta are not the authorities under the provisions of the Code of Criminal Procedure. The object of both the enactments, that is KL Act and PC Act, was to achieve common object and goal of corruption-free society. Both the legislations entail civil and criminal consequences, and both the authorities under these acts are two different sides of the same coin. With this laudable object, the police wing was deputed to Karnataka Lokayukta for performing a dual role. It is further case of the petitioner that various reformative measures were taken and implemented by the state government in compliance of the orders passed in criminal petition number 2653 of 2015. In the meanwhile, various complaints were reported to have been filed against the incumbent chief minister of the state relating to corrupt practices followed in denotification of lands in Arkhavati layout. It is learnt through the print media that disproportionate asset case was also registered against one Mr. Kapil Mohan, who is a senior IS officer of the Karnataka cadre. It is also learnt that there are cases of corruption pending investigation against certain MLAs and bureaucrats. In order to protect the scuttle, the investigation against political class and bureaucrats, notification dated 14th March 2016 came to be issued constituting ACB as authority for investigation under the PC Act. Thereby, the very purpose of KL Act was indirectly defeated. It is further case of the petitioner that as per the provisions of the Code of Criminal Procedure, the complainant is to function as a sentinel. Stop.